Hi there, good morning. This is Megan Freed. We are here to do our Choose Your Approach webinar this morning. I am looking forward to going through our presentation. Also, I want to let you know that you can chat privately in the chat screen. And so we'll be taking questions, some of them, if they're about what I'm covering at that time, we will address that question right then. Others, you can save till the end. I'll save till the end. In any case, I want to thank you for joining us. We're really glad you're here today. And with that, I am going to start our presentation. Hold on one second. And here we go. All right. We are talking about how to choose your approach today. That means that what we're going to cover is the main ways of divorcing in Connecticut. And those are mediation, which most of you will have heard of. And so we're going to do a deeper dive into what that is. But just speaking very briefly before we move on to collaborative law and low and high conflict litigation, give you a sort of visual of how mediation works. That's when the two of you are in the room with the mediator, and the mediator is there to guide your conversation. He or she will give you legal information, but will not give you legal advice. It's a neutral party who does not represent either party. So although your mediator may well be a lawyer, like for example, if Freed Marcroft is mediating, we are lawyers. But in this capacity, we'd be acting as a neutral, not as anyone's legal counsel. So it's the two people in the room with the mediator. And then we'll talk about this more later, but there's review counsel, which is the legal advisor to spouse one, and review counsel, who's the legal advisor to spouse two. Now, if you think about that for a moment, okay, and keep that visual in your head, let's move on to collaborative. Collaborative divorce is less well known, but growing in popularity and has a lot of strengths that we're going to talk about later. So here's the visual for collaborative that we put together. In the collaborative context, you don't have a neutral lawyer facilitating the conversation. You have each spouse represented by their own attorney, and then you have their financial professional, the financial professional, and the mental health professional. Those are neutral parties, right? So instead of you hiring your own financial expert, we have someone that helps both people with that. And then the mental health professional, which oftentimes we call the coach will guide the conversation, but also is available to help with issues like what's happening with the kids, how to be most supportive of them during the divorce transition. So that's the collaborative divorce model. Most frequently, that happens around a table two. This is another alternative dispute resolution approach. So you're not in court in a collaborative. Although it looks like everyone's in the room together, which does happen, it is also possible to meet separately with the financial professionals, separately with the mental health professionals. Sometimes everyone is there, sometimes just one person is there, sometimes attorneys are present, sometimes they aren't. We'll go into that more later, but in some ways, collaborative divorce is the most flexible model that we have in Connecticut. And then we have two types of litigation. So I like to separate litigation because I think that it's important to know that all Connecticut divorce litigation is not high conflict. That doesn't mean that there aren't situations where there's high conflict litigation, but there's also an opportunity for low conflict litigation as well. So first we're going to do high conflict, but before I do that, I think we have a question that is relevant to mediation collaborative law. Yes, okay. So we were asked, hi Megan, do both parties have to agree to the type of divorce to proceed? That is a great question, and I'm going to answer it now instead of later because it's good timing. Thank you. So litigation is the default process. Whether it's high conflict or low conflict, the parties are in charge of, but litigation is the default. In order to do one of the forms of alternative dispute resolution, which is also often we use the acronym ADR. So to do the alternative dispute resolution patterns, which are the collaborative divorce model and the mediation, that requires the agreement of both parties. And if you'd like to know more about that, just shoot another note and I'll make sure to elaborate on it later, sort of how that goes forward. All right, I'm going to switch back to high conflict litigation. In some senses, that's going to be what you see on TV most frequently, right? So courtroom, hearings, discovery. So let's look a little bit at what that could look like. All right. My screen doesn't seem to be going forward. There we go. Okay, great. So in high conflict litigation, see that judge there in the middle? So we have the two most important people, the two spouses, and then we have their attorneys and the judge. And you'll notice that there are financial experts in this one too. So in a high conflict litigation, you're not sharing professionals that are mental health professionals or financial professionals. In this context, everyone has their own. So as you can see, this model looks like it might be less, like the spouses retain less decision-making process. So that would be accurate. So you'll see there that we have the spouses talking to their individual attorneys, the attorneys talking to the judge, and the attorneys talking to the experts. So that's sort of high conflict litigation is the scenario in which other people are making decisions about your how your divorce is going to resolve itself, and that person is the judge. Okay, let's talk about low conflict litigation now. So in low conflict litigation, there tends to be a lot more of a cooperative approach that happens between the parties and their attorneys. So you see that the spouses might spend more time talking to each other than they did in high conflict litigation. See, in the high conflict litigation, we've got no little arrow between the spouses. So spouse one and spouse two may talk to each other. They definitely talk to their own attorneys, and the attorneys spend more time talking to each other. All right, so the attorneys are going to go back and forth speaking with each other, and then the attorneys, of course, are the ones who talk to the judge. We think of the judge in a low conflict litigation as available if there's an impasse. So basically, a lot of issues may get resolved between the spouses or the spouse's attorneys, and then the judge there is available if there's an impasse. I have a question here that's asked, that I've been asked, that's about whether or not litigation can switch from low conflict to high conflict. It can. They do go both ways. I would say more commonly, you have a high conflict litigation that moves to a more lower conflict model. So for example, if there's something that's happening at the beginning of the divorce process, for example, what's the visitation going to be during the divorce process? Or where is everyone going to be living if it doesn't make sense to reside in the same house during the process? That might be difficult to resolve, and so maybe a judge is used for that. But then once we've gotten that emergent issue settled down, it might slip into more of a low conflict role where the attorneys are resolving issues based upon their client's goals throughout the process. All right, I've got a few questions, so I'm going to pop in. All right, what's the role of minor children in the divorce process, especially when there's great contention? That could be a whole webinar. And so thank you for that idea. We can do that at a later date. One of the things that's important to know is if we look back at this high conflict litigation map, those financial experts could be experts on children, but there could also be a GAL, a guardian ad litem, in play at this scenario. And the guardian ad litem's job is to tell the court what the guardian ad litem's view is of what's in the best interest of the children. So key point with kids in the divorce process is what's in the best interest of the children. I would share, so be responsive to this question, that it really depends on the age of the children, how much input they have. But in Connecticut, we really do see judges endeavoring to keep children out of the courtroom. So things are, their opinion or their view is more likely to come in through what a client has shared with a lawyer or through a GAL's perspective than it is like with your child involved in the actual hearing or trial. Now, to answer that question, in the collaborative divorce model, the mental health professional is there, sometimes even meets with the children to get their sense of what should be going on. But remembering, of course, that these are parenting decisions most importantly. So the court focuses, and in the collaborative divorce process, the parties and their collaborative team focus really more on what's in the children's best interest than in what the children's opinion is, if that makes sense. A lot of times they're actually in alignment, but they aren't always. All right. All right. Okay. Let me check one more question before we move on. Okay. If you have an unwilling partner who may not want to litigate, but also doesn't want to take any action towards mediation or collaborative, where does that leave the person leading the divorce? Okay. So that is very common. So if you are someone who's in this situation, I don't want you to feel like you're out there alone on this one. Remember when I said that sometimes a high conflict litigation can move into a lower conflict sort of mode because people settle down after some initial issues get resolved and things start rolling? Sometimes what we do when we have someone who would really like to mediate or do a collaborative divorce, some form of alternative dispute resolution, and they have a partner who's not moving forward and agreeing to do that, what we do sometimes is we'll actually file the divorce. So start out in a litigation mode, and we'll send it with a letter that says, dear Ms., Mr. Spouse, our client, Sarah, really wants to move forward, is ready to move forward with the divorce process. That said, if you're willing to engage in a mediation or a collaborative process instead of a litigation, she remains very open to that. Here's how you contact us, all of that information. So a lot of times, litigation with a letter is a way to get someone off the mark a little bit and realize that things are moving forward and it has to happen. So that's the key about these ADR processes that can happen at the beginning. If you have a spouse that's more ready to move forward than the other, delay can happen by the person who's less ready. And so to let them know that it's going to go, we'll file the litigation, but we'll do it in this way that lets them know that all of the other options are on the table. In fact, in addition to being on the table, they're the goal of the spouse that's ready to move forward. Okay, so here I skipped a little ahead, but here's the process to resolve divorce. And in here, we're going to go a little bit more into the pros and cons of the different processes. Remember, our framework here is mediation, collaborative, low conflict litigation, and high conflict litigation. All right, so here is mediation. Now, if you remember that little visual that we did, we've kept that over in the corner for you, so that you can see it. So the mediation process, we have a trained mediator, that means has taken the mediation classes that are available, etc. So they're there to facilitate. They can provide legal information, but not legal advice, and they work to help you come to an agreement. They can also assist in helping develop options for agreement. So I think that can be a little confusing when you're not in it. So let me talk a little bit more about what that means. What that really means is, if I said to you, what do you think is a fair way to divide all of your assets? You might say something like, I think 50-50 is fair. And what I, as the mediator, would say is, oh, okay, all right, what do you mean by 50-50? Do you mean one half of everything? Or do you mean one half of the whole, regardless of how, divided in a different way? For example, do you want the house in your half? Do you want more or less retirement assets in your half? So sort of how do we divide this pie? What makes sense for both people? So that's an option that I just generated about how to think about it, that it makes sense that the parties who are divorce lawyers or divorce mediators wouldn't have thought of on their own. Financials are disclosed by both spouses. Okay. So in the mediation process, people go through the exchange of financials documents in their own. This is why mediation isn't the best option if you have a spouse who you think is attempting to hide assets or financial information. We might want to move to a different sort of process if there's someone who isn't forthright and honest. In a mediation, everyone should be comfortable speaking in their mind, because again, we have a situation where we don't have a lawyer sitting next to you. We just have the neutral. So you should be comfortable speaking in the room, and you should also be confident that you're going to be open and honest about your financials, and so is your spouse. Spouses retain separate lawyers to review the agreement with them. Okay, in that diagram over the left, that's called review counsel. So generally speaking, how review counsel works is through your mediation, you will come up with an agreement. Your mediator will draft that agreement, and then you'll go sit with your own separate review counsel so that they can give you some legal advice. Remember, the mediator's just giving you legal information. The review counsel can give you legal advice on what you might not have thought of, how a judge might rule, so that you can make sure that the agreements you've reached have been fully vetted with someone who's your lawyer representing you. It usually happens at the end. It's intended not to disrupt the mediation process. You want to find review counsel who will honor the agreements you came to in the mediation, but just give you a full sense of what you've agreed to and some counsel, right? Review counsel on whether or not those agreements make sense for you, so that you're making fully informed decisions. Financial and or child specialist neutrals can be incorporated. All right, so I didn't put those in this diagram, but remember in the collaborative model, there was a financial neutral and a mental health neutral. In the mediation process, sometimes we'll involve those folks as well. So if one person, for example, knows more about the family finances than the other person, it might make sense to onboard a financial neutral. Or to the other question earlier, if there are questions about how to best tell the children, how to best work out a parenting plan, a lot of times a mental health neutral who is there to focus on the children's issue can be a great help. So this is a very flexible model as well. Both spouses must agree in order for this to be it says collaborative, but we meant mediation. So both spouses have to agree. That's the response that I gave to that question earlier, where the ADR versions of this, the collaborative law and the mediation, require both people agreeing to go into these processes. A corollary to that, of course, is if one person wants to get divorced and the other person doesn't want to get divorced, the person who wants to get divorced has the right to go forward and get a divorce. That's why we use that litigation, to sort of give people the push they need to kind of get moving forward, even if we pull back and move into a mediation or collaborative. Then the last point here is that the mediation process limits court to the day the divorce is finalized. Yes. So one of the things that people like about mediation and collaborative is you don't spend time in court. So you will, in most cases, have to go to court only on that last day. And we have many videos that talk to our clients about what to expect on that day. But understand that, it's as limited as time in court as possible is most likely in the ADR settings, the mediation or the collaborative settings. And Laura is telling me that I have a question that this is a good time to answer. Okay, how are attorney's fees resolved relative to each litigant, i.e. spouse B's complaint includes a request for attorney's fees so as not to represent pro se. Is that common? I'm going to actually save a discussion of attorney's fees till the end, but make sure that I get to that. Okay, the next question is, when dividing assets and children, etc., do you have to have that mapped out before you file, or can that happen after the other spouse is notified? Okay, that's a great question. You don't have to have it mapped out. You can, but you don't have to. I would say in the majority of cases, we don't know that yet. And a quick comment about litigation, and it's relevant to collaborative law and mediation as well. It just happens in a different way. There are questions about what's going to happen during the divorce, and then there are questions about what's going to happen after the divorce is final. And you can and those can be different things. For example, perhaps during the divorce, someone's paying the majority of bills, and after the divorce, instead of paying the majority of bills, they're paying alimony. Or perhaps during the divorce, the couple's still living together and the parenting schedule is sort of whatever the parenting schedule has been as you lived your lives while you were married, because you're still married. And if you're living together, we don't have to work that out. But in a family where it makes sense for people to live in different houses, during the divorce, we would map out a parenting schedule, and that isn't necessarily the one that'll continue after the divorce. I hope that answers that question. Actually, I went a little further than the question, which was really about, do you have to have everything mapped out before you file? The answer is almost certainly you won't. Now, in a mediation or collaborative, we might not even file the divorce until we have an agreement, but we can enter into both of those processes without anyone knowing how we're going to handle financials or children during the divorce. The process is actually there to help you figure that out and support that. Okay, I'm going to move on to collaborative practice. Again, there's the diagram on the left. So in collaborative, like with mediation, the focus is on mutual respect. Each spouse hires a collaborative attorney. Okay, so a collaborative attorney isn't a person who says, I like to practice collaboratively. A collaborative attorney is a person who's gone through a lot of advanced training in collaborative divorce practice. So they know how the collaborative model works. It includes a divorce coach and a financial neutral. That's right over there on the diagram. So for example, what might happen in a collaborative is that you put the collaborative team together, and then the spouses talk to the mental health neutral first so they can share their most urgent concerns. And then the mental health person, our coach, brings that back to the lawyers and shares what he or she thinks is most urgent to address in the first meeting. So that goes back to the question earlier about, do you have to have resolved everything? No, we have a way to solve for that, because that's very common. Child specialists are available. Sometimes the coach and the child specialists aren't the same person. The person who's helping the spouses focus on mutual respect and creating options and reaching agreements isn't the same person who's working with the kids, but frequently they are the same person in consult with the children's therapists, if there are any. Both spouses must agree for there to be a collaborative. Yes, right? Same thing as with the mediation. It's alternative dispute resolution. The default is litigation, and then as an alternative, we can do a mediation or a collaborative, but it takes both people's agreement. Like mediation, it limits court to the day the divorce is finalized, and then clients and attorneys enter into an agreement that will not threaten litigation, and if collaborative breaks down, neither spouse's attorney can be involved in the litigation. All right, so this is the thing about collaborative that I think that can be confusing for people and is really important to understand. If you have a mediation and the mediation breaks down, the person who is serving as the neutral won't serve as either party's lawyers in the subsequent collaborative or litigation. In a collaborative divorce, everyone signs an agreement that says that if the collaborative divorce process breaks down, neither attorney can represent either party in the divorce action. Now, initially, this sounds like, but if it doesn't work, I want to keep you as my lawyer going forward. Let me explain to you a little bit about why that's an important part of the collaborative process. By making that no court pledge that we won't represent you, your respective attorneys won't represent you if the collaborative breaks down, it keeps everyone really fully engaged in the collaborative process. So at the point in it where you're frustrated or anxious and you kind of want to toss in the towel, knowing that you won't be able to keep your attorney can keep everyone pulling in the same direction. I also want to say will not threaten litigation is an important thing too. So if you're sitting around the table and you don't agree on a point, no one in a collaborative can say, that's it, I'm filing a motion. That is against the agreement, because again, the way that a collaborative is designed to work is to keep everyone pulling in the same direction and looking for creative solutions to achieve as much of everyone's goals as we can. It's not a process about making threats and running to court. Okay, high conflict litigation, the opposite end of the spectrum. High conflict litigation can involve complex financials. Sometimes the financials are just really complicated and you wind up in a high conflict situation. Spouses retain their own attorneys. The courts decide on matters. So this is when we can't reach agreements on our own. So even if you're in a low conflict litigation, there are many agreements you may reach on your own without the court's assistance. In a high conflict litigation, that's less likely to be happening. You're more likely to be having a hearing on whether the kids are going to live here and there as their primary residence, or a hearing on who's going to pay alimony and how much and when. There are trial dates for evidentiary hearings, so there's much more formal evidence process. Remember when I talked about in mediation, people need to be open and honest about their financials. In the context of a high conflict litigation, that's being done through the exchange of discovery documents, sort of like any other lawsuit, but also through the use of experts to testify as to what that means. So interim issues are decided in court instead of on the side between lawyers negotiating. There's formal discovery and expert witnesses. This is the most expensive form of litigation. The default process when spouses don't mutually agree to a mediation or collaborative and are unable to reach agreements outside court through their attorneys. So this is the default process whenever you can't reach agreements, even in a low conflict litigation. So here we go. Now let's talk about low conflict divorce. So again, this is a process when we don't mutually agree to mediation or collaborative, but I call it low conflict when you are able to reach some or many agreements outside of court with assistance from your attorneys. So this may include four-way meetings where the attorneys and clients sit together to resolve remaining issues. Sometimes you all sit at a table and hash things out. Sometimes it goes through the lawyers. Sometimes you might say something at the coffee table, sit down over coffee at the kitchen table with your spouse and resolve an issue. Court is available to resolve out-of-court disputes if parties aren't able to reach agreements. So this is one of the things that people are sometimes attracted to about a low conflict divorce model, that if you can't reach an agreement, there's a judge there who can decide if there's an impasse. Now, to switch back to collaborative, where we're trying to avoid all of that, we're trying to avoid having the judge. In lieu of the judge being there to help you reach agreements, you have the support of the collaborative team to try and help you reach agreements outside of court. With low conflict divorce, we have seen it happen where court is limited to the day divorce is finalized. Just like I talked about with mediation and collaborative law, there may not be any issues that happen that need a court's decision. And so we wind up we wind up with a situation where we have parties appearing only on the date their divorce is finalized in court. And formal discovery and exchange of information remains an option. So in this context, you have the formal discovery process that's there if people need to know what's best for the kids, if people need more financial background information. This is available in a low conflict divorce, just like in a high conflict divorce, and in fact is very common. All right, so I'm going to switch modes and talk about the decision-making process now, because one of the things we've realized here is that we spend a lot of time gathering information. When I say we, I mean we humans. So the steps of the decision-making process are to identify problems and goals, to gather information, to create options, to weigh possibilities, to make a decision, and then take action. That question I received earlier that was about someone that's not moving forward with the divorce process, that sounded to me like we had a spouse who was at the take action space, who was the one asking me the question. And then we had a partner who was not at the take action space yet. So let's learn a little bit more about the process, and I'll explain how this all comes together with choosing your approach. All right, so identify problems and goals. You've probably identified your problem, but without experienced guidance, it's hard to truly focus on and determine your goals. So this is the thing at Freed Marcroft we designed our goals and planning conference around, is identifying your goals. So we're good at identifying our problem, but we're bad at identifying our goals. Let me give you a classic example. My problem is that I no longer want to live with my spouse. I just can't take it anymore. We're fighting. It's acrimonious. I think it's bad for the kids. I just don't want to do it anymore. My goal is to not live with my spouse anymore. Nope, that's not your goal. Your goal is something deeper, more nuanced, that is harder to get to. So the identify problems and goals, the goal is not the absence of your problem. We have to dig way deeper to get to it. Step 2 is to gather information. Generally speaking, most of you on this webinar are probably in this stage where you're gathering information. You've probably spoken with family or friends, read articles, watched webinars or videos, and spoken to professionals. You may have attended a workshop. So you're gathering information, perhaps on what process is best, perhaps on what an outcome might look like, on what the options are, how long things take. Gathering information. Then you create options, all right, considering staying in the marriage, working with a therapist to try and improve the marriage, leaving the marriage, weigh your possibilities, make a decision, and then take action. The reason I have this up is because a lot of people get stuck at point 2, gathering information, and they don't move through so that they can take action. You can gather information for as deep and wide as the internet is. You can talk to every friend, you can talk to every family member, you can gather high quality information, you can gather low quality information, but it doesn't get you to making a decision and taking action. So don't get lulled into over gathering information in order to avoid getting through 3 and 4 to 5, which is making a decision and then to taking action. So this is how we've designed things at Freed Marcroft to help you with that. So the Goals and Planning Conference is there to help you generate the options, which will scoot you right through 2, 3, and 4, 2, 3, 4, and 5 of the last slide there. So we do the Goals and Planning Conference so that we can actually get to your goals rather than your goals being the opposite of your problems. We put together a legal team that makes the most sense for you. And I want to talk about that a little bit here, because in this context, right, part of the legal team that I'm going to put together for you is the optional approaches that you might be considering. So sometimes we might meet with people who think their spouse might be interested in a collaborative or a mediation, but they're not sure yet, right? So that means I need to put together a team that allows for any one of those possibilities. Gather initial information. All right, there's going to be a new client questionnaire where we gather some really initial information from you that we need in order to get you going and have the best plan set up for you as possible. The make a plan. This is when your legal team sits down with the priorities list that you came out of in the goals and planning conference. So that's your goals actually on a list where they're prioritized. And they put together a strategy session agenda for you. And at that strategy session, which is your first meeting with your full legal team, you make a plan. Then we move to 5, address any immediate concerns. Again, I got great questions this time. Thank you so much. That's when we loop back to addressing those things that feel urgent. Ooh, where are we going to live? Who's picking up Joey from soccer, right? Let's figure out how to address those concerns. And that happens in all of those processes. It can happen in a litigation, it can happen in a collaborative, and it can happen in a mediation, so that everyone can get their life sort of a little bit settled down so that they can think clearly and everyone is on the same page while the divorce process is happening. Then we prepare initial documents, continue to position for resolution, and then complete the divorce, and you move forward with your life. In the interest of full disclosure, steps 6 through 9 happen more slowly than steps 1 through 5. But for purposes of this chart, that's the high level scheme of where a divorce goes. And this is more about that goals and planning and hiring your legal team and gathering initial information just a little bit bigger so that you can see it better. And then there's 4, 5, and 6. And 7, 8, and 9. 9 being move forward with your life. All right, so that is the presentation that I have. I'm going to turn to some questions that we have remaining. So let me tell you what those are, okay? One of them is, okay, will this recording be available after? All right, yes, we will circulate the recording after. 100% you will be able to access that. Oh, and then I also have a good question here, okay, about how to decide whether or not what process is most expensive to enter into. All right. Usually when people say expensive, they mean in terms of legal fees. So I'm going to address that, but I want to bring things out a little bit higher up, a 30,000 foot view. Your divorce can be expensive in terms of your time. Your divorce can be expensive in terms of financial money. Your divorce, of which legal fees is a part, but your settlement, your alimony, how cash flows is really the expense of a divorce. And then your divorce can be emotionally expensive, whether it's to you or your children or some combination of both. So that's really like the things you have to weigh are what is the most important factor to you. That's something that goals and planning conference that I talked about focuses on. That's step 1. So as we develop your goals and options, one of the things that we're also going to work on is what is most urgent to you. Other than the initial things, I need to know where I'm living. I need to know where my kids are living. I need to know how we're paying the rent or the mortgage this month. But other than that, really, is it most important that you get through this process quickly? Is it most important that you get through this process retaining as much of the assets you've accumulated as possible? Is it most important that to you that you think you'll accumulate assets, more assets later on, so you're less concerned about what you've saved or accumulated thus far? You're more concerned about alimony or child support, which I collectively call cash flow, how cash is going to flow. For different people, that's different. Is it most important to you that your children are emotionally unscathed through the process, that you're emotionally unscathed, that your spouse is emotionally supported? All of those things are part of that goals and planning conference. So the answer to which process is least expensive in terms of legal fees is the process that makes the most sense for your family is least expensive in terms of legal fees. So I told you that a high conflict divorce is often the most expensive model. That is a hearing on every issue, a trial on every issue, experts, the lawyers spending days in court. That is the most expensive in terms of legal fees. A low conflict divorce, a mediation, and a collaborative, that is really about all about picking the right model. And what we do here, sorry if I'm going too fast, right? So we go through the goals and planning conference, and then when I put together your team, that is going to be set up to help them make a plan for you in the context of your strategy sessions. So there are things that you're going to share with your legal team, or they're going to read in your priorities list, that are going to tell them that one process versus another is going to be the best for you. And what I'm saying is the process that is the best for you and is most in line with your family's capabilities is going to be the most efficient in terms of legal fees. So here's an extreme example. If you do a mediation where both parties are in the room and one of them is afraid to talk, and the mediation falls apart and you wind up in a high conflict litigation, that is more expensive than if you just started with a high conflict litigation. If you wind up in a scenario where you're doing a high conflict litigation, you can always move it back to a low conflict litigation and keep fees lower. All right. So that's some context around that. Now, okay, I have another question that I want to answer. How are attorneys' fees resolved relative to each litigant? Right, we talked about this, i.e. spouse B's complaint includes a request for attorney's fees. All right, so in the US, our model is that each party pays his or her own attorney's fees. So if you have a scenario where you have a contractor remodeling your house and there's a dispute as to whether that contractor did the work correctly and you sue the contractor, you are going to pay your own way and the contractor is going to pay the way for his or her defense. That's the basic model. In the family law setting, this is more nuanced because it's a family where the money is the family's money, even though it's in an individual's name. So for example, a good thing to know about divorce in Connecticut is that Connecticut is an equitable division state, right? So on TV, often because people are more familiar with California law that make TV, they talk about the California model, or they reference that a lot, where everything that was accumulated during the marriage is split 50-50. All right. That's not the case in Connecticut. In Connecticut, the judge can divide things equitably. And in the mediation and the collaborative context, of course, you two can decide what's equitable for you, and that's how you can arrange things. So it's not a clear 50-50 in Connecticut. And that goes into play with attorney's fees too. There, in a collaborative or a mediation, there's a good chance that you're going to have a discussion about fees, and fees are going to be taken out of the marital pot before that marital pot is divided in the way that you've agreed. In a litigation, your attorney's fees won't necessarily be equal. It can be more expensive to have a lawyer on one side than the other. Perhaps that's because the lawyer's rates are higher. Perhaps it's because there's simply more work to do on one side. An example of that would be if someone is the income earner and has complicated stock options, or perhaps owns a business, is an entrepreneur and owns a business, or is a professional and is a partner in an organization, odds are that that person's legal fees might be higher because of the work that their legal team has to do to provide the discovery that is part of the divorce process. So that's something to think about as well. So sometimes the requests for attorney's fees that are in a complaint, sometimes if one spouse has access to more of the family's resources than the other, those resources will be used to pay for the other spouse's attorneys. That can be decided early on too in any of the contexts, whether it's by agreement or by a judge making that ruling. All right, I think that that is the end of our questions. So I want to thank all of you. This was a really engaged group, and I love it when it's interactive. This is my favorite webinar to do, so I want to thank you all so much for being here. And that's it. If you need anything, please feel free to write to us at info@freedmarcroft.com. If you haven't come in for your goals and planning conference yet, please come in for your goals and planning conference so you can work through the deep issues, and then you can move on to figuring out which approach you're going to go into with your legal team. If you've already had a goals and planning conference and have been discussing things with your spouse, give us a call and give us an update on how we can be supportive for you. Oh, and I just got a thank you note. Thank you for the thank you. I really appreciate it. Everyone have a wonderful rest of your week and happy second day of fall.